In this lesson, we're going to move away from talking about the various different principles of the UK Constitution. If you remember, these principles included things like the separation of powers, the idea of the rule of law, and what we spent a lot of our time on, which was this idea of parliamentary sovereignty. And we're going to move on now for the next few lessons to start talking about the sources of the UK Constitution. Now, this lesson is going to be a very brief overview of what those sources actually are that we're going to be talking about in the future. And it should be noted that some of these sources are going to have more lessons than others, because some of them are more important than others, some of them are more difficult to understand than others, for example. So, like I said, moving away from the general principles of the UK Constitution and examining the sources of the UK Constitution instead. And one of the things that's important to just as a very brief introduction, just to outline for us all here, is that the reason why we have different sources relating to the UK Constitution is because of our constitutional framework, because of the nature of the UK Constitution. Because the UK Constitution is what we call an uncodified constitution, this means that it is not derived from one single document. It's not like the US Constitution, where we see one single document from which we derive all of the general principles, and there are 27 amendments that we attach to that. Instead, we have a single document that is, we have no single document that is codified, that is the UK's Constitution. Instead, we have to look at a variety of different sources from which we derive our constitutional framework. And I've mentioned multiple times what the consequences of having an uncodified constitution actually is. So, for example, or are, should I say, if I'm going to use grammatical English, we've mentioned the fact that we have a lack of entrenched principles. Generally speaking, there is no law that cannot be overruled by something else, owing to the principle of parliamentary sovereignty. We've seen some minor challenges to that in relation to the Thoburn case and the idea of there being maybe constitutional statutes, but for the most part, even then, it is still the case that you can overturn, if you are Parliament, overturn any legislation that was previously passed. In addition to this, we also have the view that the Constitution is very flexible. It is easily changed. In fact, arguably, whenever a new piece of constitutional legislation is passed, it is changed. It does change, and it is shaped and molded very, very quickly. And if we look to reference the common law as well, whenever there are new common law decisions that are made, that also changes and modifies and develops the Constitution. So, like I've said, the UK Constitution is uncodified. It's not written down in single place. Now, some people and even some textbooks like to make this false comparison, in my opinion, between the idea of an uncodified constitution and the idea of an unwritten constitution, arguing that the UK's constitution is not written, is an unwritten constitution. I believe that that's a little bit misleading when it comes to explaining how the UK's constitution works. I can understand why certain textbooks and certain professors may or academics may cite it in that particular regard, but I would argue that uncodified is a far more precise way of defining the nature of the UK Constitution rather than unwritten, because unwritten implies that it is unwritten, implies that it is just a bunch of conventions and general rules of thumb, whereas in reality the UK's Constitution, the vast majority of the UK Constitution is written down. The thing that is different from this constitution and, say, for example, the US Constitution or a variety of different European constitutions is the fact that it is not all written down in one single place, in one single document. That's why we suggest that it is uncodified. And so as a result of all this, we see that the UK's constitutional framework is divided into a multitude of different sources. And the sources of the UK constitution that we're going to be exploring are as follows. We're going to talk about statute law and secondary legislation first. Again, we're not going to spend too much time examining it because we've talked about parliamentary sovereignty already. We've talked about what statute law is, how Parliament operates, and all these different things. But then we'll also talk about the law of the European Union, very briefly, and I've put a little asterisk there because, of course, there is this tricky situation that we have to think about when we talk about Brexit. No longer does the European Union apply its law to the United Kingdom, but there are still lots of old law that still exists that is, to an extent, still derived out of and came from the European Union, even if it is still applicable in the UK. I will then talk about the common law, which is the judge-made law which is created by the judiciary. And then we'll start to talk about some of the more interesting and unique elements of the UK Constitution and its sources. So we'll talk about, for example, constitutional conventions. What are constitutional conventions? How are constitutional conventions made? What are the significance of constitutional conventions? And what are some of the examples of constitutional conventions? I'll then talk about the royal prerogative as an element of the UK Constitution, specifically the idea of the Constitution or the UK being a constitutional monarchy. The idea that the monarch still has quite a large amount of political and legal authority within the UK's constitutional framework, before finishing by talking about various different works of authority which exist and will contribute to the UK's Constitution, some of which we have already explored in previous lessons.